Hello, good afternoon and good evening to everyone. Thank you very much for joining us. Good afternoon and good evening to everyone. Thanks for joining. My name is Lillian Hardy, and I am the local DC chapter president of the Berkeley Law Alumni Association. And I'm the class of 2006. I'm really excited to be here. Both because this is a Berkeley event and because it's a DC event. We've talked in small groups and large groups about how to make a more meaningful presence for our law school community on the East Coast. And we know that here in Washington, DC, we have both the intellectual curiosity, the breadth of experience, and the commitment to Berkeley law that we can sort of become a center of excellence for alumni associations. And so we want to do that and bring that as we continue to get together. So today we are getting together to discuss a very important topic, which is the path forward for American democracy. We're going to hear from Dean Chemerinsky, which is always a joy and a privilege for all of us. We want to say that, this should be the first sort of official event you attend with us, but certainly not the last. I encourage you to get in touch with the Alumni Association supports that we have, Doreen and Mary and others, and certainly me, if you have ideas to become more engaged with our group here in DC. Or if you would like to help put on an event or host something. So without further ado, I would like to turn it over to Dean Chemerinsky.
Thank you so much. Thank you. Thanks to all of you for coming. Berkeley Law is late in creating regional alumni chapters. We've now begun to do so. We have regional alumni chapters in Silicon Valley, San Francisco, Los Angeles, DC. We're going to create one in New York. And it is exactly as Lillian said, the chance to engage our alumni in the law school in a much greater way. I look forward to, as soon as travel opens up, coming and personally meeting with those of you in the DC Alumni Chapter, as well as doing this all over the country. So right now, most of all, I just want to say thank you for being part of this. I was actually asked to do two talks. First, I want to give you a brief state of the law school update. And then I want to talk to you about a book that I'm just beginning to work on, which ultimately is, as the title suggests, The Path Forward for American Democracy. In terms of the state of the law school, I think you know that all of our classes were online for this entire academic year. On the one hand, we showed we could do it. We succeeded in providing an excellent education to our students. On the other hand, I think it's just not the same as being in person. I taught both a seminar and a large class each semester this year, and I realize how much when I'm in the classroom, I'm looking for the visual cues from the students, looking to see, do they look confused? Am I losing their attention? Or those wonderful moments of energy in the classroom that you only get in person, and none of that's possible online. There's no doubt that frustration grew over the course of the year. People were isolated. We couldn't build the community we usually do. On the other hand, the student evaluations were better this year than we've ever seen before. At Berkeley, the average median student evaluation is about a 6.01 or a 6.02 on a 7-point scale. In the fall semester, it was 6.10. In this semester, it was 6.30. So it may be just grade inflation on the part of the students as they're ranking their professors, but I think it also shows how hard the faculty work to learn to teach this new medium. The good news is our plan is to be entirely in person for the fall 2021 semester, which will begin on August 16th. A letter went out to all of the students explaining that we expect all classes to be fully in person beginning on that day. We're not going to have a hybrid option available. The only possible exception, we have a student for a medical disability needs and accommodation, And even then, what we're likely to do is to provide asynchronous recordings. We've decided that the public health situation and the educational situation calls for being back in person. So unless there's some unexpected developments, I am so looking forward to at 8:40 on August 16th, walking into the classroom for my federal courts class and seeing the students. Several other updates about things. Let me start with admissions. I never thought I'd be in a situation of saying we have too much good news, but we are way over enrolled for the fall. We are not unique among law schools in this regard. To start with, our applications soared. A year ago, we received 5,500 applications for a hoped-for entering class of 320 students. This year, we received well over 8,000 applications for what we wanted to be a class of 320 students. Nationally, applications were up, but we're up about twice as much as the national average. I hope that reflects good things being thought of and said about Berkeley Law. We wanted to have a smaller class than this year, so we accepted about 5% fewer students. But the yield was at an impressive level. 37% of all the students who we accepted said yes to us, about 10% what it usually is. So at this moment, we have 420 students enrolled for a class where we wanted 320 students. And it is a terrific class by every measure. The median LSAT is 169, which was the first time in Berkeley history we've ever reached that. The median GPA is 3.84, which was the highest we've ever been. It continues to be a tremendously diverse class. One of the things that I'm most proud of during my time as dean is how we've been able to increase the diversity of the class. When I arrived in the fall of 2017, there were only 12 Black students in the first year class. I was tremendously worried and that to create a downward spiral where prospective students would come here and not see many Black students and choose to go elsewhere. We did a careful study to identify where we were failing. It wasn't in applications, it wasn't in admissions, but it was in yield. So especially relying on our alumni, we developed an aggressive program of reaching out to those we had accepted. And the number of Black students increased the next year to 28. In my third year here, it increased to 33. Last year it was up to 43, and that's where we are for next year's class as well. We've also increased the number of Latinx students, the number of Native American students, and next year's class looks to be about 65% women. There's a lot of uncertainty about LLM admissions in terms of visas, but we're over enrolled there too. So I have to admit that I'm spending a lot of each day now planning for what happens if we continue to be over enrolled at this level in the fall. It'll obviously create all sorts of difficulties, but we just have to find a way to make it work. Second thing you might be interested in is faculty hiring. And the good news is we are continuing to hire terrific faculty. We have 2 new faculty who will be joining us July 1st. Jennifer Chacon, who's a professor at UCLA Law School. She specializes in constitutional law and immigration law. And Jonathan Glader, also a professor at UCLA Law School, specializes in education law and also teaches in the criminal law area. This past year, we added a couple of wonderful new faculty members, Asad Rahim, who will be teaching contracts and teaching the race in the law area, and Chris Huffnagel, one of the leading experts in the country in privacy law. And the year before that, we added 9 new faculty members. Overall, if you count Jennifer and Jonathan, we've hired 21 new faculty members since 2017. I don't think any law school can say that it's done that. And we're continuing this. We're looking to hire about a half dozen more faculty members in the coming year to start in July of 2022. The hard part of all of this is so many of our faculty members have visiting offers from top law schools. We have, I think, 3 faculty who are going to be visiting at Harvard, 3 who are going to be visiting at Stanford, and so on. So we also spend a great deal of time on retaining our faculty. We've been successful for a couple of years, and then we lost a couple of faculty who will be leaving us this year. And it is one of our real challenges as a public school where we can't provide some of the benefits that private schools can. I'll give you an example. All of the other top 10 law schools, public and private, provide college tuition remission for faculty children. I was at Duke before I came to the University of California, and it pays for 3/4 of your children's college tuition for any college in the country up to the value of the Duke tuition, which is very high. UC has no tuition remission program. Most of our peer schools have very generous housing programs. We don't. And so it's challenges for us in recruiting and retaining faculty. You might have seen the rankings this year, especially what's called the specialty rankings, I think really reflect our across the board strength. We're number 1 in intellectual property. Some of these are ties, but number 1 in IP, number 1 in environmental law, number 2 in criminal law and procedure, number 3 in business law, number 6 in constitutional law, number 6 in international law, number 7 in contracts and commercial law, number 9 in clinical education. Very few law schools in the country, if you did the overall rankings like this, would be ahead of us. We would clearly be in the top handful of law schools. Our overall ranking is 9. And it's interesting to think about why the disconnect. Say Virginia, that's 8, and we're 9. In the areas that I mentioned to you, we're ahead of Virginia in every one of them and tied in one of them. Well, a lot of that is the artifact of the US News ranking. US News ranks schools in part based on per student expenditures. As a public university with the lowest tuition of any top 10 schools in a fairly large school, we do poorly relative to our peers in per student expenditures. But it's even worse. US News discounts our per student expenditures by about 20% based on their cost of living adjustment. And it adds a 5% boost to Virginia based on its calculation of cost of living. Just because of the cost of living adjustment, we are 9 rather than 8. If per student expenditures were not considered by US News, we'd be tied for 6 in the US News rankings. So it all has to be put into that context. Overall, what I've shared with you is the good news. The hard part of this year has been the financial aspect. We have become, as you may know, very dependent on international students and LLM revenue because of the pandemic, because of visa issues, because of being online. Our LLM program this year was half the size of last year, and we lost $9 million in revenue this year compared to last year. Our overall budget this year is about $115 million. The campus, we don't get very much from the campus. A year ago, it was only 7% of all of our revenue, but they cut us this year by $2.5 million. So figure out we only got about 5% of our revenue from the state this year. We last year got $1.8 million from the University of California Office of the President for some programs. They cut this year to $1.3 million. And so if you do the math, we lost $12 million in revenue that we had a year ago compared to this year. And so much of our budget is fixed costs. About 70% of our budget, 68% to be precise, is faculty and staff salaries and benefits. We can't cut that. Almost 20% of our budget goes to student scholarships. One of the ways in which we've succeeded in recruiting great students is we've dramatically increased the amount of scholarships we give over the last few years. The year that I came, both the third year class and the first year class got $3.6 million in scholarships. It was $3.6 million a year. Now each class is getting about $7 million in scholarships, but we can't cut that. So it made it tough for us, but I was committed that we would have no layoffs of staff and that we wouldn't compromise the educational program in any way. And we succeeded. We succeeded in part because we didn't have to pay for travel. We succeeded in part because we didn't have to pay for in-person events. We left some non-essential staff positions open. We tightened our belt, but overall we ended up with a deficit of significantly under $3 million. We do have a cash reserve and we were able to cover it through that. And how we'll be next year financially is so much going to depend on the LLM program. And also I'm very hopeful that our development efforts will yield more dollars, and certainly the support from our alumni has never been more important than it is right now. So I will be glad to answer questions about anything you want to ask concerning the law school, but I was also asked to talk about another very different topic, the path forward for American democracy. I believe that the last 7 months have been the greatest challenge to American democracy and the rule of law that the country has ever seen. It's not hyperbole. The guardrails of our democracy held, but just barely. Never before in American history had the defeated incumbent president tried so hard to stay in office and to undermine the outcome of the election. We all know that Joe Biden won the popular vote by 7 million votes, and we all know that he carried the Electoral College. There were 33 lawsuits filed across the country by my count, by Trump and his supporters, and he lost, and his supporters lost 32 of 33 such lawsuits. The only one they won was a lawsuit about being able to stand closer to those who were counting absentee ballots. Every claim of voter fraud was rejected by the courts. If you haven't read it, there's a decision by Judge Bibas of the Third Circuit. He was appointed by President Trump to the Third Circuit. He was a conservative law professor at the University of Iowa and University of Pennsylvania before going on to the Third Circuit. And in the strongest possible language, he said, there was no evidence of voter fraud whatsoever. And yet, according to an opinion poll I recently saw, 30% of the population, 70% of Republican voters believe that Donald Trump should be president now, and the election was stolen from him. It's so easy to imagine a scenario where the guardrails of democracy wouldn't have held. What if the election officials in Michigan and in Georgia had decided that Donald Trump was to get the electoral votes of those states? Michigan has a 4-person commission with 2 Republicans and 2 Democrats. One of the Republicans would have not certified the election for Biden, but it took the other Republican, the 2 Democrats, to do so. But easy to imagine, what if it happened? Or what if the Secretary of State in Georgia had done what the President of the United States asked and found the additional votes to give the state of Georgia's electoral votes to Trump? What if the state legislatures, where they were controlled by Republicans, in states Biden carried, had given that state's electoral votes to Trump rather than Biden? What if the Michigan, or the Pennsylvania, or the Georgia, or the Arizona, or all of them had their legislature say, it doesn't matter what the people said, we believe that Trump won, we're going to give our state's electoral votes to Donald Trump? What if the courts had come out differently? I think the courts were the real heroes in this story. Judges, whether they previously been Republican or Democrat, whether they're known as liberal or conservative, whether they're federal or state, without exception, found no evidence of fraud. What if on January 6th, Vice President Mike Pence had done what President Trump requested and said that he wasn't going to certify the election for Joe Biden? None of these are far-fetched possibilities, and I worry what they portend for 2024. After watching all of this unfold, as we all did, to November and January and since, I decided that what I wanted to do was to look more systematically at what are the problems facing American democracy and how do we solve them. And I've done a book proposal and to the publisher, and the book is just beginning, and so it's not due until well into 2022 and won't be out until 2023. But our development office is kind enough to ask me to share some thoughts about it. What occurs to me as I think about the threat to American democracy is that it's not new, that the problems that our democracy faces were actually built into the Constitution from the very beginning, and that it's a series of things that have occurred in recent decades that make these problems particularly acute. Let me be specific and give you examples. One problem is the Electoral College. If 49,921 votes had come out differently in Arizona, Georgia, and Wisconsin, then Donald Trump would have won the Electoral College. 49,921, I think, is less than fits into the football stadium on our campus. Certainly less than fits into many baseball stadiums and football stadiums around the country. 49,921 votes different in 3 states. And it didn't matter that Biden won by 7 million votes. Trump would be president. Twice in this century, in 2000 and 2016, the candidate who lost the popular vote won in the Electoral College. That almost happened in 2004. Had John Kerry won Ohio, he would have prevailed in the Electoral College, even though George W. Bush won the popular vote. Today, states with 22% of the population can choose the president through Electoral College. The problems of the Electoral College existed from the beginning. Alexander Hamilton in the Federalist Papers talked about how we needed the Electoral College because of distrust in the people. So we needed an elite to choose the president of the United States. The Electoral College was chosen in part to protect the institution of slavery. Southern states would have not had their slave population couldn't vote and would not play any role in their influence in choosing the president. And this was widely known at the time. The Electoral College gives each state the number of electors that's equal to its representatives and senators. In allocating representatives, the Constitution, Article 1 says that slaves would count as 3/5 of a person. So the slave population of states, which factor in the number of representatives, would also factor in the number of electors. This was noted at the time. Hugh Williamson, a delegate to the Constitutional Convention from North Carolina, praised the Electoral College on this basis. James Madison, a delegate to the Constitutional Convention from Virginia, praised the Electoral College for letting Southern states have influence choosing the president based on their slave population. A second critical flaw in the Constitution that's manifests itself concerns the Senate. As part of the Great Compromise, every state was given 2 senators, regardless of size. In 1787, the population of Virginia, the largest state in terms of population, was 12 times the size of the population in Delaware, the smallest in population. After the 2010 census, the most recent data, the population in California was 65 times that of Wyoming. Let me put this to you in another and contemporaneous way. The 50 Democratic senators today represent 42 million more people than the 50 Republican senators. Not only because of population, but also because of changes in the rules with regard to the filibuster. For much of the 20th century until 1975, if a senator wanted to filibuster, he or she would have to hold the floor, as Jimmy Stewart did in Mr. Smith Goes to Washington. And at any point, there could be a cloture vote, so senators who wanted the filibuster would have to remain in the Senate. In 1975, the Senate changed the rules for the filibuster. So a filibuster would not slow down the business of the Senate. So that now all that it takes to filibuster is the Senate indicating a desire to do so. The Senate goes on with its other work, but it then takes 60 votes to pass any legislation. Unless it's a budget reconciliation bill or an appointment of a cabinet member, federal judge, or Supreme Court justice, It takes 60 votes to pass it in the Senate. And all of this then makes it so much harder to adopt legislation. If you think about the American Rescue Plan that was passed in January, 70% of the American people expressed their support for it, but not a single Republican member of Congress voted in favor of it. Had it not been a budget reconciliation bill, it would have never gotten adopted. As I'll talk about, there's no way that voting rights legislation or police reform legislation or infrastructure reform is going to be adopted so long as the filibuster. A third institution created by the Constitution is the House of Representatives. It was meant to be the one representative institution created by the Constitution. But because of partisan gerrymandering, it's ever less so. Partisan gerrymandering is nothing new. It takes its name from the governor of Massachusetts, Elbridge Gerry, who engaged in the practice early in American history. It's where the political party that controls the legislature draws election districts to maximize their seats for that party. But what's changed is, because of sophisticated computer programs, it's possible to engage in partisan gerrymandering with far more success than ever before. Take North Carolina as an example. North Carolina is basically a purple state. It went for Obama in 2008, Romney in 2012, Trump in 2016 and 2020, but always by narrow votes. Republicans gained control of both houses of North Carolina legislature. And then they said their goal was to redraw congressional districts so as to give Republicans control of 10 of 13 seats in the House of Representatives from North Carolina. The written report was candid. It said it would try to give North Carolina Republicans control of more than 10 seats if they could figure out a way to draw a map to do so. They had a computer draw 3,000 different ways of having election districts drawn. They picked the one of the 3,000 that maximized the chances that Republicans could win 10 of 13 seats. It worked. In 2016, Democrats and Republicans statewide got almost the same number of votes cast for House Representative seats, but Republicans won 10 of 13 seats. The exact same thing happened in 2018. This is not atypical. You see in North Carolina, you see in other states, both for House of Representative seats and also for state legislatures. The only exception is the handful of states like California that have independent districting commissions. A challenge got brought to the North Carolina districting. A 3-judge federal court found that it violated the Constitution. But 2 years ago, in June 2019, in Rucho versus Common Cause, the Supreme Court held that challenges to partisan gerrymandering are non-reviewable political questions. In other words, courts can't hear challenges to partisan gerrymandering. The result is that after the 2020 census, when there's redistricting for House of Representative seats, state legislatures, in almost every state, all but the handful like California, partisan gerrymandering can occur with impunity. The fourth institution created by the Constitution, in addition to the President, the Senate, and the House, is, of course, the Supreme Court and the federal courts. There's certainly a relationship between what I've already discussed and what we see for that. Take Brett Kavanaugh as an example. He was nominated to the Supreme Court by a president who lost the popular vote. He was confirmed by senators representing 44% of the population. There has been, for a variety of reasons, the development of a substantial imbalance in the Supreme Court. And here's what to me is a stunning statistic. Since 1960, or from 1960 to 2020, we've had 32 years with a Republican president and 28 years with a Democratic president. In fact, in 2024, we'll have had 32 years with a Republican president and 32 years with a Democratic president, exactly even. But since 1960, Republican presidents have appointed 15 justices to the court, and Democratic presidents have appointed only 8 justices to the court. Almost 2-to-1 Republican presidents being able to nominate justices compared to Democratic presidents, even though Democrats and Republicans held office the same amount of time. Some of that's just the accident of history for when vacancies have occurred. Richard Nixon got 4 vacancies in his first 2 years as president. Jimmy Carter got no vacancies in his 4 years as president. Donald Trump got 3 in his 4 years as president. But some, of course, is also the way in which the Republicans blocked the consideration of Chief Judge Merrick Garland, the way in which the Republicans rushed through the confirmation of Amy Coney Barrett. Also, the anti-democratic nature of the court has increased as life expectancies of justice has gotten longer. Clarence Thomas was 43 years old when he was confirmed for the Supreme Court, 1991. If he stays on the court until he's age 90, the age was Justice Stevens retired, Thomas will be a justice for 47 years. Or another example, Amy Coney Barrett was 48 years old when she was confirmed for the court on October 26th. If she remains on the bench until she's 87, the age at which Justice Ginsburg died, Barrett will be a justice into the year 2059. To me, the features that I've talked about, the anti-democratic nature of the Electoral College, of the Senate, the House, of the Supreme Court, were built into the Constitution from the beginning. But things that have changed in recent years, the realignment of the parties and how it's contributed to what's occurred in the Electoral College, the shifts in population, the filibuster of the Senate, sophisticated partisan gerrymandering, we discussed with the courts, all enormously exacerbate the anti-democratic nature of our government. And we are seeing now systematic efforts in many states to try to further subvert the electoral process. The laws adopted in Georgia, Florida, Arkansas, the ones that are proposed in so many states, are very much designed to suppress Democratic votes, and especially votes of people of color. And one thing that has not gotten the attention that I think deserves it is the way in which some of these laws would shift who determines who gets the electoral votes of the state from election officials to party officials for the state legislators. So my goal is to try to propose solutions and suggest a path forward for American democracy. To start with, I think there needs to be reform of the filibuster. I would argue that the filibuster should be eliminated. It's unconstitutional, I believe, because the Constitution prescribes when it wants supermajorities. It says it takes 2/3 vote to approve a treaty or 2/3 vote to overrule a veto. It doesn't say that for passing legislation. It clearly indicates where supermajority is required. So only majorities are required for legislation, not 60 votes. I think it's undemocratic in allowing senators to represent less than 25% of the population to block legislation, and it's highly undesirable. At the very least, we should have reform of the filibuster. Perhaps we could have a situation where the first vote requires 60 senators to agree to end debate, but then a second vote would be 55, and a third vote would be 50. Or maybe we just return to the old talking filibuster to make it much less likely. The difficulty right now is especially Senator Joe Manchin has said he won't engage in reform of the filibuster. But if not, I don't see, as I said, how we're going to get the necessary voting rights legislation or police reform legislation or infrastructure. I think we need to focus on how we're going to reform the Electoral College for the future. I do not see any way in which the Electoral College will be eliminated. That would take a constitutional amendment. To amend the Constitution demands that 3/4 of the states approve it. The states that benefit from the Electoral College are never going to vote for such a constitutional amendment. But I think there's other changes that might happen with regard to the Electoral College. For example, one of the problems of the Electoral College that increases the likelihood that the loser of the popular vote can become president is winner take all. Winner take all exists in all but Maine and Nebraska. Whoever wins the popular vote in the other 48 states gets all the electoral votes in that state. If someone voted for Donald Trump in November 2020, California, or voted for Joe Biden in Texas in 2020, it's as if they didn't vote at all. The ideal would be to find some way of allocating electoral votes proportionate to the popular vote in each state, which I've seen statistical analysis show make it much less likely that the loser of the popular vote could ever be chosen as president. I think in terms of the House of Representatives, it's essential that we go to having independent commissions draw districts rather than legislatures. One of the things that a proposed bill that's passed the House of Representatives would do is say that in every state, there has to be an independent commission to draw election districts for House of Representatives seats. Unfortunately, that's being held up by the filibuster. I think with regard to the Supreme Court, we need to think of dramatic reforms in terms of things like increasing the size of the Supreme Court, things like term limits for Supreme Court justices or mandatory retirement age for Supreme Court justices. Thankfully, life expectancy is a lot longer today than it was in 1787. In 1787, average life expectancy was 36 years old. Now, of course, we regularly see justices into their 80s, even in their 90s serving, which I think only increases the anti-democratic problems of the federal judiciary. So my goal is to try to take each of the problems that I identify and offer solutions. And I think that if we draw any lessons from the last 6 months, it's about how fragile American democracy actually turns out to be. I never thought we would see the kind of threats to democracy that we've experienced. We've now all seen them. And I worry there's a tendency for everyone to feel sanguine. We got past it. Biden ended up in office, but I worry that's exactly the wrong lesson. I think the lesson we have to draw from all of this is the simple reality. Democracies are there until they're not. No form of government lasts forever. We can look around the world and see so many countries that were democracies that are no longer democracies. We're naive and we're simply wrong if we think it couldn't happen here. And I think in that sense that we as lawyers, we as a law school have a special responsibility to do all we can to go forward and protect American democracy. I was asked to talk till 2:40, or I guess it's 5:40 your time. I've done that. And at this point, I'm glad to take any questions that you want about the law school or about this new writing project I'm taking on.
Thank you, Dean Chemerinsky. That was fabulous to hear everything about the law school and also about your project. What I'm going to do now is walk through some of the questions that have come in from the audience, and I think I will take them in reverse order. We'll talk first about your writing and what you've shared with us just now, and then we'll close with questions about the law school. So first question that comes up is, you mentioned that the last 7 months were the most challenging and pivotal in our democracy. And one colleague would like to know, do you think this period has been a greater challenge than April of 1861? And if not, would it be a close second to that period?
It's difficult to compare. Of course, that was an actual civil war, and a civil war that lasted for 4 years. And in that sense, this isn't a civil war. And yet, that wasn't an effort to have an insurrection and overthrow the American government. It wasn't to undermine the results of the election. So in one sense, the reason I chose the words that I did is I think that this is different from the Civil War. I'm not saying that that wasn't a challenge to the country. Of course it was. I am saying, though, that what we saw between November and January is something that we've never seen before. I mean, the more we learn, the more we realize that Donald Trump was doing everything he could to stay in office, notwithstanding the results of the election. And had he succeeded, we would no longer been a democracy. Had the South seceded, we'd still, at least the northern part, would have remained a constitutional democracy. Maybe another way of talking about this comparison is I think our country is as deeply ideologically divided as it's been since the Civil War and Reconstruction. And I think the question is, what's the path to bring the country back together? I had said a couple of years ago that it's usually a crisis that brings a country back together. The last time our country was truly unified was after 9/11. George W. Bush had 90% approval ratings then. I think there was an opportunity to bring the country together with COVID-19. I think the president could have said in March of 2020, we're all in this together. We're all going to have to sacrifice together, and we have to follow the science, and we have to do whatever's necessary to eliminate this terrible disease. That's not how it played out. Instead, the pandemic more politicized the country and further divided us than ever before. And so in that sense, I worry the divisions that occurred that led to the Civil War are different than the divisions that occur today. We can certainly talk about the ways in which they're similar, but it is a country that is so deeply divided. And where is the bridge that's going to heal us?
Thank you. The next question we have is, as long as the Senate is organized as it is, it will tend to create majorities from less populated states. Isn't the filibuster a potential tool for allowing the more populated states to keep the less populated states from enacting undemocratic laws? So in other words, can this be used to the advantage of people in the right place?
It can be in theory. Of course, my hope is that the House of Representatives already provides that benefit because the House is allocated on the basis of population. And so the more populous states have more representatives in the House and can protect themselves. My concern is that if you look at population, senators representing less than a quarter of the country can block legislation that the majority wants. You know, I've heard it said that the danger of the Democrats eliminating the filibuster now is when there's a Republican president and a Republican Congress, the Democrats won't have it available as a tool. But that assumes that the Republicans won't eliminate the filibuster when there's a Republican president, Republican Senate, and the Democrats use it. Think back just 4 years ago to the spring of 2017, when the Democrats filibustered the nomination of Neil Gorsuch to the Supreme Court. The Republicans just changed the Senate rules to eliminate the filibuster.
Thank you. Another colleague has asked you to address the class action lawsuit pending against the U.S. government brought by protesters that were injured last June in that infamous moment when President Trump came across the square for the op-ed. The Justice Department is asking that this case, sort of proceed, be thrown out. What are your comments about that?
It's always difficult to sue the United States government. The United States government has sovereign immunity. There is the limited ability to sue it directly under the Federal Tort Claims Act. And of course, we could go into detail about it and the 26 exceptions to the Federal Tort Claims Act, one of which is for the discretionary functions of the United States government. It's always very difficult to sue federal officers. The Supreme Court has made it ever more so by narrowing the availability of so-called Bivens suits and by expanding qualified immunity as a defense. And it's always very difficult to sue the government for the failure to provide protection or failure to do enough to safeguard. Key case here was a case in 1989 in the Supreme Court DeShaney versus Winnebago County Department of Social Services. Joshua DeShaney was a 4-year-old boy who was severely beaten by his father and suffered irreversible brain damage. Joshua's guardian sued the Department of Social Services, saying its failure to respond to complaints of child abuse over a 2-year period cost Joshua his liberty without due process. And the Supreme Court ruled against Joshua, saying the government had no duty to protect him from his father. The court said the government has no duty to protect people from privately inflicted harms. In April of 1991, after the verdict acquitting the officers for beating Rodney King, the then chief of the Los Angeles Police Department, Daryl Gates, pulled out the police from certain aspects of South and Central Los Angeles. As a result of that, there were riots where individuals got terribly injured. I'm sure you all remember the lawyer, Johnny Cochran. Remember the O.J. Simpson case? Johnny Cochran and I together filed a lawsuit on behalf of Reginald Denny, a man who was pulled from his truck and beaten at the corner of Florence and Normandy in Los Angeles. And we said it was a deliberate choice on the part of the Los Angeles Police Department to not have police in this area following the verdict acquitting the officer beating Rodney King. And the court dismissed it, saying that you can't sue the government for the failure to provide protection. So I'm not saying that this lawsuit is going to fail. I am saying that it faces a lot of hurdles.
Thank you. Another question related to some of the activity that we've had right here in DC. The question is, compare the situation of the January 6th protests where basically, protesters were allowed to attack the Capitol. Why should that group's First Amendment rights be protected by the government and another group be punished for voicing their concerns? This colleague has shared that their son and his girlfriend were protesting that day and that they aren't part of the suit but did sustain injuries.
There's no First Amendment right to engage in violence. The violence that occurred, the insurrection of the Capitol, is not First Amendment protected behavior. There's also no First Amendment right to incite illegal activity. If you look at the words of Rudy Giuliani on the morning of January 6th, if you look at the words of Donald Trump on that podium on January 6th, I think there's a strong argument that what they engaged in was incitement of illegal activity. So I do not believe that those who engaged in the insurrection can claim First Amendment behavior. Those who were peacefully protesting on the mall, who didn't breach the Capitol, they were exercising First Amendment rights. That's not what we're focusing on here.
Thank you. The next question is, do you think that the interstate compact to pledge electoral votes to the national popular vote winner is constitutional?
I'm not sure it's constitutional, but I am convinced it'll never work. It's a very clever idea where the states say, we'll pledge our electoral votes to whoever wins the popular vote. So therefore, in the Electoral College, the winner will be the winner of the popular vote. And it's being done through a compact of the states. To start with, so far, only blue states have ratified that compact. It'll never get enough states to make it work. But there's an even greater problem. It's not enforceable. Imagine that prior to the 2020 election, that Texas and California and enough states, red and blue, had signed into the compact. And imagine that Donald Trump lost the popular vote, though won the vote in Texas. And imagine Texas would be decisive in the Electoral College. Do we really believe that Texas would say, we signed this compact, we're going to honor our promise, we're going to give our electoral votes to Joe Biden because he won the popular vote, even though Trump carried Texas, and even though our doing this will make Biden president? I don't think for an instant they would have done that. But you can also imagine the reverse. Imagine a situation where it's the Republican candidate who wins the popular vote and loses in the Electoral College. And California was a party to that. And if California only went the other way, the Democrat would be able to become president. I don't think California would obey its promise in terms of the compact. It's just unenforceable. In terms of constitutionality, I'm sorry. I was just going to say, in terms of constitutionality, there can't be a compact that brings about a substantive change in the Constitution. And I think there's an argument that this would do that. But I'm less worried about the constitutional issue and more concerned about the practical reality.
Thank you. So Dean Chemerinsky, we will take one more question on the second topic and then move to our questions on the law school. This question is, which I think is highly appropriate for this DC community, should DC become a state, and how about Puerto Rico?
Yes, DC should become a state. I have an op-ed that's going to come out in the Washington Post in the next few days arguing why it is constitutional, and clearly so, for DC to be a state. And if Puerto Rico chooses to vote for statehood, it should become a state as well. But ultimately, it has to be a choice of Puerto Rico whether it wants to choose the path of statehood. And I know that is a divisive question there. But if Puerto Rico voters choose for statehood, they should become a state. We all learned in some civics class that there shouldn't be taxation without representation. That was one of the bases of the Revolutionary War. And yet, for all of you in DC, you have no senator. You have no voting representatives in the House. If you're in Puerto Rico, you pay taxes. And yet you don't have representatives in the House or the Senate or votes in the Electoral College. And so, yes, I strongly favor DC statehood and Puerto Rican statehood if the residents of Puerto Rico vote for it. Again, it won't happen because of the filibuster. If Congress didn't have to worry about the filibuster, there's no doubt it would pass the House and the Senate now.
Thank you. So I think we'll wrap up our program by talking about our school again. And I think it's the right way to wrap up, because we're hoping that this community really rallies to sort of bolster our reputation so that we can move from slot 9 closer to slot 6. US News can't hold us down. I'm convinced of that, not when we have this kind of community. But some specific questions for you, Dean Chemerinsky. Do you think that the California state budget surplus can have any chance of helping our budget situation at the law school?
The University of California is receiving less and less over time from the state of California. Many of you who went to law school earlier paid very little in terms of tuition. My wife graduated from Berkeley Law in 1986. She paid $750 a semester. That's because the state of California was subsidizing the law school. This year, we'll get less than 5% of our budget from state money, from campus money. The problem is that the state has also dramatically decreased the amount of money that they give to the University of California overall. The last two governors, Brown and Newsom, have not been strong supporters of funding the University of California. They have forced the campuses like Berkeley take more students, but provide them less in the way of resources. If there's the political will to do so, then there would be the ability, using the large budget surplus, to give money to the University of California. Some of that would come to the Berkeley campus, and some of that would then benefit the law school. But so far, there doesn't seem the political will. I'm very concerned about the California and nationally, the lack of legislative and popular support for public education.
Thank you. The next question, and I have to say I've heard this question posed in other spaces, and that question is about law schools in general having support for the student group, the Federalist Society. Can you respond to whether or not that's an active student group that's funded by the law school, and what their level of activity is, and your position on that?
Sure. I believe a law school should be a place where all ideas and views should be expressed. I believe that a campus should be a place where all ideas and views should be expressed. I want us to have conservative views expressed, and liberal views expressed, and ideally the opportunity for dialogue. We're all better off if we have our ideas and views challenged and have to defend them and have to hear opposing points of view. We do have an active, a vibrant Federalist Society chapter. Money for all student organizations is apportioned by what's used to called the Student Bar Association, is now called the Students of Berkeley Law, SABLE. And the Federalist Society gets its allocation the same way all student organizations get their allocation. The only thing that makes the Federalist Society a little bit different is that the Nationalist Federalist Society is incredibly financially well off and also provides financial support for the school chapters.
Thank you. And the final question we'll have for you for the program is addressing here the alumni community here in Washington, D.C. What can we do from our seat here in the nation's capital and in the various environments that we occupy? What can we do to wave the Berkeley flag? Thank
you. I so want you to be involved with the law school, and I so want to find ways for all of our alumni to be more actively engaged. Let me rattle off several things, but this isn't exhaustive, and it's really up to you and be creative. Creating the DC Alumni Chapter is a wonderful step towards being involved with the law school. Helping us to recruit students. We have, this year, about 2/3 of our students are coming from outside of California. We're always competing with other schools for students. If you could help come to events, host events, reach out to admitted students, and to help us in that regard, it would be very useful. Put on programs, substantive programs for the alumni and for others. And it's, I think, a wonderful service to do that. And I'm glad to encourage our faculty and others to come speak at those programs. In terms of other ways of being engaged, obviously financial support. Let me give you a statistic that to me is very powerful. We have now about 19% annual giving among our alumni. It's just gone up a little bit, and we're at 19%. As I mentioned to you, the University of Virginia is ranked just ahead of us in US News. It's also a public school. It is 55% alumni participation in annual giving. Michigan, which is ranked right below us and is also a public school, has 36% alumni participation in annual giving. Even if you're just going to give $25 or $50, if we could get all of our alumni to be engaged in helping a little bit in financial support, it would make a huge difference. So your support, whatever it is you're able to do, would be enormously appreciated.
Thank you. I agree wholeheartedly that you gave us a lot of good ideas. I would say if anyone wants to go ahead and send those ideas to me as our president, I'd be happy to action them and work with our team to get them done. But before we close here, alongside, thanking Dean Chemerinsky for spending his time and everyone for coming, I wanted to share an announcement. We have with us this evening Victoria Braidman, who's the president of the Cal Alumni Association, so the broader Berkeley Alumni Association DC chapter, and she has shared that the California Alumni Club of Washington, D.C. will hold its annual summer picnic on the 31st of July at Cabin John Regional Park. It's the first in-person event that will take place. I'm going to go ahead and place in the chat the link to register for that event. You can sign up to receive newsletters and get involved with other sort of Berkeley-centric items, which is an important thing for us to do as well. So just again, want to thank everyone for coming, encourage everyone to continue being involved here, and have a wonderful evening. Thanks, everyone.
Thank you.